All right, the next case to come before the court is State of Ohio versus Duane Barlow. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, let me know when you reach the podium. I'll keep track of time for you and let you know where you stand. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and stay behind the podium. You should not use the name of any children or victims if that comes up in an argument. We have read your briefs and are ready to proceed when you are.
Good morning again, Your Honors. Giovanna Bremke on behalf of Mr. Duane Barlow. I would reserve my 5 minutes. Mr. Barlow was charged with burglary, a felony of the 2nd degree, and domestic violence. Originally charged as a felony of the 4th degree, but amended to, on the first day of trial, the only day of trial, to a misdemeanor of the 1st degree. Mr. Barlow was found not guilty of the burglary, so we're not here on that. We're just here on the misdemeanor domestic violence. It did proceed to a bench trial, and my 2 assignments of error are manifest way of the evidence and sufficiency. In this case, Mr. Barlow and his wife had a relationship. Many couples do. They were separated but not divorced, and they had children to exchange. He frequently went to it was the marital home, frequently went to this marital home, pick up the children for visitation, drop off money. In this case, he was dropping off money. He didn't even intend to go inside the home. He went up to the door to drop money into the mailbox. His wife comes out of the house. They have some words, and she, and I should note as well, he notified her before he was coming over. She starts questioning him about his new relationship, and then she lunges at him, and this is sort of on the front porch by the door. They, have a tussle. She yells to her son, and I won't say the direct quote, but essentially he's going to jail, call the police. They have this mutual fight. His car is still running because, again, he just went to go drop the money in the box. She goes to his car. He attempts to get her out of the vehicle, and she grabs his phone and goes in the house, grabs a knife, stabs him in the butt, and actually he suffers severe injuries. And he had to seek medical attention. He had an IV. He testified he was screaming in pain. He was covered in blood, and there was a large chunk of flesh missing from his butt. There's exhibits that show this. Severe injuries. In this case, again, he's justified in self-defense. She used deadly force. The wounds that were caused were extensive. They were almost to the point where it would be like an attempted murder. It was extremely extensive. He had to seek medical attention. She was originally handcuffed but never charged, and he was charged. The force is justified in that this was deadly force, and he's defending himself. Not only that, but it was a bench trial, and in delivering the decision, the trial court states that it was not firmly convinced on who started the argument. And again, we're focusing now on the domestic violence because the burglary was not guilty. And the trial court says, there's more peaceful ways of getting your property back, and that the trial court says it's unclear of whether the injury suffered. So essentially what I think the trial court is trying to say is that this argument on the porch and the argument by the car, the argument on the porch, he says, I'm not firmly convinced of who started, both arguments, and then the argument by the car where Mr. Barlow attempts to get his wife out of the vehicle, that he says, that's, I believe he said, the court saying that that's where the domestic violence conviction comes in. But, again, she had used deadly force. It wasn't until that car incident that the knife came out and the deadly force was used. He's defending himself, he's defending his property, and the court makes these statements, it's unclear whether the injury was sustained right there or during the other engagement, and I think that he's referring to the house engagement. In the fact that it's unclear, that's reasonable doubt. Again, the court explicitly expresses a reasonable doubt. In addition to that, the wife, I'll just say wife because I know we're recording, but the wife suffered no injuries. There's testimony to that. She's very inconsistent with her testimony, completely incredible. She, and I quote in the second assignment of error, every single time when she says she doesn't remember. She says, it's been a year, I don't remember. I don't remember whether my hair was pulled when originally that was a big issue. I don't remember how I got on the ground, which again, when she's on the ground in the lawn, that's where the court finds this domestic violence. And she's saying, I don't remember how I got there. Well, she doesn't remember how she got there, and the court's unclear on how it happened. That's not enough to justify a conviction. She repeatedly says, I don't remember what happened. She says, that's what happened, but I don't remember. It's completely incredible. And additionally, she had motive to get him charged. She says it initially. They're in the middle of this divorce and separation. There's a custody situation going on, and he's in a new relationship. So again, these convictions, by explicit, discussion on the record of the finder of fact, that there was doubt. There's clear doubt. The court says they're not firmly convinced, that they're unclear, and that's page 128 of the transcript. It's expressed doubt, and that's not enough for a conviction.
Thank you.
Good morning, Your Honors. May it please the court, Lindsay Poprocki on behalf of the state of Ohio. Appellant Duane Barlow has challenged both the sufficiency and the weight of the state's evidence to support his domestic violence conviction. I'd like to expand on those arguments, and the state would submit that Barlow has not demonstrated that the state failed to meet either its burden of production or persuasion. As to his sufficiency argument, Barlow claims that it was clear that any force he used was justified in defending himself, and that in his brief he claims that it would be a miscarriage of justice if he was not granted a new trial on domestic violence. As this court is aware, however, where a defendant challenges the sufficiency of the evidence, he is arguing that the state presented inadequate evidence on each element of the offense to sustain the verdict as a matter of law. Here, Barlow does not set forth the elements that he feels the state failed to prove for each conviction, for his conviction, and appears to cite a standard for this court, which sounds in weight and not sufficiency. This court has consistently noted that sufficiency and manifest weight are two separate and legally distinct arguments. Further, Barlow's argument that evidence of self-defense existed is a form of defense. To that end, it was Barlow's burden to establish that he acted in self-defense by a preponderance of the evidence. Barlow's argument that any force he used was justified in defense of himself does not lead to the conclusion that the state failed to prove the elements of domestic violence because sufficiency review does not include affirmative defenses. Nevertheless, Barlow's conviction for domestic violence was supported by legally sufficient evidence. In viewing the evidence in a light most favorable to the state, the trial court reasonably could have found that Barlow knowingly caused physical harm to the victim. As the trial court stated at sentencing, this conclusion was drawn in large part by Barlow's own testimony, where he admitted using physical force on the victim. Barlow's own testimony confirmed that he pulled the victim's hair after he grabbed her by the back of her shirt while she was in the car and then threw her to the ground. Any response, or Barlow's argument as to deadly force came after he chased her into her home and was after he used the force that he used in the tussle outside, and after he admitted that in doing so he used a fair amount of force. For these reasons, Barlow's sufficiency argument fails. In claiming that his conviction is against the manifest weight of the evidence, Barlow argues that the trial court clearly lost its way in convicting him because the court expressed doubt at sentencing as to who started the confrontation, which may have indicated support of his self-defense claim. A challenge to the weight of the evidence goes to the credibility of the evidence presented. While the trial court did indicate that it was not firmly convinced who started the altercation, it clearly indicated that it was firmly convinced of who did what, and later it indicated that the bottom line was that Barlow used force and admitted it. It clearly gave substantial weight to Barlow's own testimony and was clearly based on this statement, it was not persuaded that Barlow acted in self-defense, and it was Barlow's burden to establish that he did so. As we've heard, Barlow also attacked the credibility of the victim in maintaining that his domestic violence conviction is against the manifest weight of the evidence. He's claimed that she had a motive to attack him and that she offered inconsistent statements at trial. This court has repeatedly noted, however, that the duty to evaluate evidence and the credibility of the witnesses is primarily for the trier of fact. A conviction is not against the manifest weight of the evidence simply because the trier of fact chose to believe the state's version of the evidence. Here, the trial court was able to assess the evidence and the credibility of the witnesses. And here, both the victim and Barlow testified at trial. The trial court clearly placed significant weight on Barlow's own testimony, where he admitted to using physical force on the victim. He admitted to using a fair amount of force on the victim when he pulled her hair, threw her out of the car, threw her onto the ground, and tussled with her over the phones. It found him guilty of domestic violence based on that testimony. He was not responding to deadly force when he committed any of those actions. For all these reasons, the state requests that the court overrule Barlow's 2 assignments of error and affirm his convictions and sentences, as his conviction was supported by both the sufficiency and manifest weight of the evidence. Thank you.
You have your full 5 minutes.
Thank you. The state contends that Mr. Barlow hasn't shown that the state failed to meet its burden of persuasion. But I would present to you again that the state's key witness, the wife, is completely inconsistent. Again, she doesn't remember she has zero recollection, essentially, of this incident, except for the fact to say that she was injured, or to say something happened, I'm sorry. But essentially she says, there's no injury. Originally she said her hair was pulled. She says in the stand it wasn't. She has motive, and the ultimate proof that that the state failed to meet the burden of persuasion is the fact that the trial court expresses clear doubt. There's a long discussion, fairly long discussion on the fact that the state is not, or that the trier of fact, the court in this case, was not firmly convinced, that they were unclear on what happened, and that they had doubt about the conviction. So I would ask that you reverse these convictions and send them back to the trial. Thank you.
All right, thank you. Thank you both for your presentations. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides in due course and posted on our website and that of the